When the FCPA was first enacted or conceived, I think the focus really was on US persons or entities, whether these US persons are physically within the US or outside of the US. But there were subsequent amendments to the FCPA, and then we have seen the application of the FCPA through case law. And there are, of course, certain high-profile prosecutions. And what we can see is that there seems to be a greater risk for non-US companies, to the effect that a non-US company can get caught under the FCPA even with very little business connection to the US. For instance, there are certain high-profile cases where the defendant is caught merely because it is listed in the US, or it is caught because it has a correspondent banking or financial services account in the US that it uses as part of the transaction, even if the bulk of the business transactions take place completely outside of the US. So that causes concern for global citizens, really. And also the FCPA can apply even if an act of bribery is done by a subsidiary of a US company, even without the knowledge of the parent. So even if it's completely without the knowledge of the parent, it can cause issues for the parent under the FCPA. So apart from the width of the FCPA, we also see more activist enforcement. So the Department of Justice in the US has actually issued statements to the effect that enforcement actions will now focus on corporate individual executives with the threat of actual imprisonment. And that's a very, very strong deterrent rather than the payment of a fine. So you can't run the argument that a company is too big to fail anymore. There are also more aggressive enforcement strategies, for instance, the use of wiretaps, the use of enforcement or undercover agents, so that could cause a greater or more real risk to anyone that has got a US nexus. And remember that the US nexus is something that can be relatively easily established. Just to move on to the UK Bribery Act. In certain respects, the UK Bribery Act actually is more expensive than the FCPA. And it also applies to foreign companies for transactions outside of the UK, so long as there is a close connection with the UK. And that is quite, in actual application, that can be quite easily met. The other way that the UK Bribery Act is broader than the US FCPA is that the FCPA only focuses on the giver of the bribe, someone who offers a bribe. Whereas in the UK Bribery Act, it makes it an offense for someone to give or receive a bribe, and there is also a separate offense for bribing a public official. So that's broader. Whereas in the FCPA, yes, if you receive a bribe, you tend to be prosecuted for under money laundering laws rather than under the FCPA itself. The UK Bribery Act also applies if a person associated with the company pays a bribe, even if he has no close connection with the UK. So the concept of an associated person is quite key, and even if the act falls outside the extra-territorial reach. So in that respect, it is broader than the FCPA. I think the first step is to assess whether you are within scope or not, and that may or may not be easy depending on how complex your business operations are and the jurisdictions that you operate, the correspondent accounts that you use, whether you're listed in the US, etc. So that needs to be done. But having in place a robust ecosystem is important. So most companies would have some form of policies and procedures, gifts and entertainment policy, setting limits as to what gifts you can give or the amount of entertainment you can provide or receive. But that in itself is not a complete solution. The thing about policies and procedures is that they need to be practical, they need to be updated, they need to be communicated effectively. They need to be bought in by everybody, really. No point having a set of policies and procedures and nobody reads them. Yes, the culture is important. The whole concept of having the policies to be very practical, very useful, very risk-focused is also important. And then how you communicate this to the entire constituent or universe of constituents is important. The right messaging from management is important. The kind of training that you provide, whether it's online training or face-to-face training or blended training, which is what we like, is important. Some companies put in representations in legal agreements where they work with a counterparty or a service provider. You get representations that there's been no violation of bribery legislation. So that's something you can do that quite carefully, and they should extend not just to the persons you deal with immediately, but also agents or subcontractors. And as you rightly pointed out, getting the right compliance culture, because policies and procedures will never be able to foresee all conceivable fact and situation. There will always be something that's not caught under a policies and procedures, and you need your employees, your staff, to be guided by an instinct to do the right thing, and to be guided by an instinct to escalate things if something appears to be not correct or to be wrong or to be unethical.
Yeah.
I think from a Singapore perspective, apart from the UK Bribery Act or the US FCPA, they need to be also concerned with the Prevention of Corruption Act that would apply to them, their employees, their officers, which also has got extra-territorial effects. So if you give a bribe outside of Singapore and you are caught by virtue of being a Singapore citizen, for instance, there's the immediate concern for you is whether you're in breach of Singapore's corruption laws. So you find an overlay of it is entirely conceivable that you might be subject to the Singapore's Prevention of Corruption Act, the US FCPA, and the UK Bribery Act.
Right.
It is entirely conceivable. So you need to be able to have a compliance program that addresses all these overlapping rules and regulations.